Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Each week, normally, I host an episode of eDiscovery Leaders Live where I get the chance to chat. We've got a lot of competition. Noise behind us here. Chat with luminaries in eDiscovery and related areas. This week, however, we are broadcasting from the Georgetown Advanced eDiscovery Institute in Washington, D.C. We are outside the main meetings rooms in the area with all the vendors like us.
Yes.
But we're obviously not alone from the number of people who are standing behind us. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. My guest for this session is Ryan Tilot. Ryan is of Counsel with Gunster.
Yes.
Ryan, welcome.
Thank you. Happy to be here. Thanks for
Glad to have you here.
Yeah.
So let's start with that of Counsel at Gunster part.
Yeah, so I've just moved to Gunster about 2 months ago. Florida-based law firm. Really excited. They've been building a eDiscovery practice, national eDiscovery practice now for the last 18 months, and I've worked with some of the people in the past, so I was excited to meet back up with them and work with them down in Florida.
What's your role look like?
So, we are acting as National eDiscovery Counsel for a lot of clients. So most of our work is, working day to day, helping clients deal with their eDiscovery issues, litigation readiness, and then also kind of quarterbacking counsel, when you have multiple outside counsel law firms working on related matters for clients, helping them make sure that there's consistency across the entire EDRM model.
So you are there as eDiscovery Counsel, then there are merits counsel as well.
Right.
Maybe your law firm, maybe other firms.
Correct. Exactly. Oftentimes in that role, it's the other firms.
Okay.
And then we also do service matters that Gunster handles when Gunster's the merits counsel as well.
How many of you are, so I assume it's a group that's doing that,
Correct.
Not just you.
Yes, that's
Yep.
right. That's right. We have 8 attorneys, and then we have 5 or 6 technologists, project managers, who also are in the practice group as well. And so we're dedicated full-time just to eDiscovery and information governance issues.
What's the makeup between the two, eDiscovery versus information governance?
Well, so we have information governance analysts, right? Non-practicing attorneys. Some of our attorneys, like myself, focused on IG matters for a long time. And as they're interrelated, right? Privacy, security, information governance, and eDiscovery litigation. So I'd say there's a smaller group, 3 or 4 of us, who are dedicated to the IG practice.
No, why the move?
That's a great question, right? I've been in big law for a long time, over a decade. But I think, you're seeing with the industry and the way things are changing, a lot of people who have now been in eDiscovery for a while, looking really for leadership opportunities to work with clients. And when you're at a big firm, there's challenges, right? So as we discussed before, there's conflicts, issues, even where merits counsel may be working on the case and eDiscovery, having it be sort of its own separate practice can sometimes be challenging at a law firm. So a big law especially. So I was looking for a long time for either a medium-sized firm or boutique, and the Gunster folks gave me a call, and I'm happy to be on board.
Great. So what other advantages are there to being at Gunster, or at least a Gunster?
Sure. Well, I think too, as I said, when you're quarterbacking counsel, right? When you're working with other large firms, you're really seen as more of a partner, right? There's not this potential for competition, right?
They're
Like,
not worried that you're going to try to steal the underlying work.
exactly. And so I think that we become a trusted partner in that sense. And I said too, also with conflicts, right? You have sometimes, the matter may unfold. You might have to help out with data issues and other areas. And, if more conflicts come up, then you're limited in being able to help that client. So I do think that medium-sized firm model or a boutique model does have a lot of advantages. And, we have great talent that have come from large law firms, the training. But I think, too, you're seeing with e-discovery being around now so long, you can really draw from talent from so many different areas with expertise, both on the legal side and the technology side.
What are you seeing as some of the big issues in the e-discovery space?
Well, and we've talked about this at other conferences. I mean, the collaboration platforms, right?
Everybody's concerned, right?
Yes. I mean, and they're in the concern mode, right? But I do think it's going to rapidly increase. Already businesses, because of the pandemic, have adopted Slack and Teams and other tools that allow them to collaborate, allow them to communicate. But that's also creating a lot of data, which the service providers, I think, are really working on ways of trying to refine and being able to handle that data all the way from identification, collection, processing, review, and I think, as you said, right, it's something we've seen in the past. There's new technologies. It will take a little bit of time as things mature and develop, but I do think that you could see a rapid growth and once you see more and more litigation, it's going to be, I think, a real challenge for a lot of corporations, a lot of outside counsel, as these requests come through.
I tend to think that I will put my old litigator's hat on, and I think of all these newer sources of data, not just as challenge, but as opportunity.
Absolutely. And I think in terms of that opportunity, I think there's also that framework that's there, right? Like, for example, even with teams, using custodial questionnaires and being able to actually talk to and interview the custodians, identifying, what chats or groups were they actually communicating in, right? As opposed to, oh, well, Teams is just a source of data that we're gonna look at. But I think too, in terms for the litigators, as you said, there's great opportunity because this is a new type of set of data that is being generated, created on the fly. Not, emails much more measured oftentimes, right? In the terms of the way the custodians are formulating email. But when you're talking about potential issues with Slack or Teams, these are chats. This is, kind of contemporaneous thoughts and communications that
perhaps a little rawer, perhaps a little more revealing.
Exactly. Right. Yes. Reveal. Yeah. No. Had to plug that. But you're absolutely right. And I also think it can be a benefit too for litigators, right? Where now you're getting information that might not necessarily have been in those emails, but can still be beneficial or, could be tough for your litigation as well.
So as you were talking about that initially, I got this. I don't know if it's Alice in the Looking Glass, Alice in Wonderland, or some other book picture in my head of you using a Teams meeting to work with a custodian to look at what they have in Teams.
On Teams.
So
you're right.
The Teams are showing up on the screen in Teams.
Yes.
And then it just goes on and on.
And I have done that. And now that I didn't think about that, but you're correct. Yeah, I mean, luckily that Teams should be privileged, right? That's work product.
Right.
But the Teams, yes, you're looking at. But you're right. It's Teams within Teams within Teams. And like I said, a lot of times just talking to custodians, they're not even fully sure, like, where they were, like, were they in the meeting, chatting in the meeting? Was this a side chat while a meeting was going on? It's interesting, right? I think.
I tell you, no.
No, right.
I wouldn't be able to answer those questions.
No, and especially for the litigator, that's a real challenge. So I think, that's been one of the strategies that I've found is really effective is sitting down on a Teams chat with that custodian, looking at their Teams to identify what are the important conversations that they were having, what documents were being shared.
So this is something I don't think, this is episode number 129, if I'm counting correctly. I think this is the first time anyone's brought up the use of Teams or Zoom
Really?
as a method of communicating and working with a a custodian
Yeah.
to do the custodial interview. You've been doing those, I take it.
Yes.
How do those work? How does that compare?
I mean, it was a necessity, right?
Right.
During the pandemic, you couldn't interface. I've found it useful because oftentimes you're in a conference room, right, with that custodian, or you're usually in a setting where they're not maybe as accessible. I mean, you can sit down at the computer with them and identify where do you save data, but
Right.
it's been really helpful and useful. And doing it live, you as the litigator can see information that you might not necessarily would have seen otherwise, right? Whereas
While also seeing the custodian.
yes, and their cat pictures and everything else that you find mixed in teams. But
Right.
I've found it very valuable because it's similar to like if you were able to sit down with the custodian and talk through some of the emails or other sources of data. So yeah, the team's interview approach has been really beneficial.
The only thing it's not going to do is show you the box sitting under the desk.
Correct.
That you might want
You can still ask them about it.
Yeah, but you won't see under the
No,
desk.
you're
You
right.
won't notice like, okay, what's that thing you got shown?
Yes, yeah.
Right.
What are those discs?
Yeah. And do we have anything that can read those discs?
Right. So.
Okay, so we got, I'm thinking, new sources of ESI and all that comes with that, the collaborative platforms. How are the lawyers, the litigators, if you will, that you work with, dealing with those forms of content, Slack, Zoom, all the various chat, email platforms? Are they figuring out how to make good use of those in their investigations and lawsuits?
I mean, it depends, right?
Of course.
And I mean, at first it is about the education. So at my prior firm, I did a roadshow going around from office to office, talking to litigators, first of all, because you're starting to see some adoption in law firms of Teams and other tools, right? But they still tend to be very document management system heavy, right? And that's sort of their focus.
Yes.
And so I think a lot of litigators haven't appreciated, first of all, the proliferation and how often these tools are being used in the business, right? So that's number one, it's education. And then two, by them appreciating it, it helps them, ask, I think, the right questions. So I had a case in the last year where the entire case was all about information that was conducted in Teams. The entire case. So and it brings up a lot of issues to think about, right? Like attorney-client privilege when you're communicating with an attorney or asking or providing legal advice. Who else is on those teams, right? Who has access?
Is it a direct message?
Right. Is it of 800 people in the department? Is it with people outside of your organization? So again, it's about education, thinking about those issues. But a lot of times, even though it's a newer source, it could be, quote, scarier, I think it also can help you get right to the issues in the case. And I think the service providers have been doing a good job of being able to collect the information in a way that is useful for review. But that also, it takes, again, some consideration up front before you process that data, right? How are we going to make that look from a document standpoint? And
what do we want to make it look like?
Right. And the rules allow strategy there, right? I mean, it's how it's kept in the normal course of business versus, potentially changing that format to make that.
And what it looks like on this PC versus this iPhone versus that Mac over there.
Yes.
There's no one source of truth as to what it looks like.
No, correct. Absolutely. And then, of course, it's that other issue that everyone wants to talk about now, modern attachments or documents that are linked or shared. I mean, I think you and I probably don't agree on this issue, but
we'll see.
What?
I'll see what you have to say, and then I'll let you know what I think. How unfair is that?
I mean, I would say that I don't believe that that an attachment or the link to that document is an attachment to that message. I don't believe that they're the same. They're connected. I think it's different than when you attach a document to an email. That being said, if it's still responsive,
Mm-hmm.
it's still responsive, right? And
Right.
and therefore, I think that hyperlink helps you identify where that document sits, where it
Mhm.
resides, and if it is responsive, it needs to be collected, processed, reviewed, and produced. But I also think that could change if the architecture, in my view, were to change, right? If they weren't so separated. That's, I guess, where I sit
So
right now.
let's try to parse this out a little bit.
Yeah.
And see where we get with this. So one is there are technological differences.
Correct.
Right? It's not an actual attachment.
Yes.
You don't have an EML message or something like that has the file
Right.
attached to it. It's
Right.
a link
Yeah.
to a file that's somewhere else.
Correct.
What difference does that make? I mean, it makes a lot of difference in terms of the ability to collect data,
Mm-hmm.
and it poses some challenges for processing.
Correct.
What difference does it make in terms of the discovery, the legal discovery of the content?
Well, but I also think here's what I would say, right?
Yeah.
Like, so say for example, that message could be responsive, right?
Yes.
But I could see where the content of where that link sends you to is not responsive,
Which
right?
is true of any
It's
attachment, right?
it is, but I also think that there is a difference then. I mean, and that's I guess the question.
We don't have a right answer right now. I mean, there's
Agreed.
not a definitive legal
Correct.
opinion on this. We
Agreed.
have some decisions out there.
And I think it's also
So we can go whichever direction we want here.
Yeah.
Right?
But I think at the end of the day, right, in the cases that are out there,
Yeah.
you say, right, if it is responsive, no matter if it's a
Mhm.
we're going to call it a hyperlink, we're going to say it's somewhere else, then
Yeah.
then that is responsive. But I do think there can be that distinction, and I mean, there's some differences where some hyperlinks might not be in the possession, custody, or control of the corporation.
It might not be accessible. You might not be
Yes.
able to get at that content.
Right, and whereas that is, again, even though there's a technical difference, that can make that has a legal ramification.
Right. That's got a meaningful difference. If you can't get at it,
Correct.
you can't do anything.
Exactly.
One of the other issues, and I haven't seen this addressed so much, although there must be discussion about this out there, is that link sometimes is to a static document.
Right.
Sometimes it's to a living document.
Right.
We've got a Word, let's assume you and I are
Yeah.
working on a
Versioning.
Word file.
Mhm.
And instead of sending that Word file back and forth, we've decided to be much more efficient.
Right.
And both have
Here's
a
the
link to that document, which is sitting in SharePoint.
Yes.
And I make edits, and you make edits, and I make edits. And we continue to do that for 6 months to come. We end up in litigation. Those 6 months to come don't count, but this week counts.
Yes.
But no one's dealing with this stuff until a year down the road.
Right. Right.
Are they going to
And so
be
now
able
you
to
have
find what we
preservation.
did this week?
Yeah. No, I absolutely.
Yeah.
That's that's challenging. And I've seen
Yeah.
too, not as difficult, but people can edit, right? Like a Teams
Right.
chat. And I've seen where the custodian had no idea that when they were editing and changing
Uh-huh.
and deleting, and that's still there.
So I have not tried to figure out the answer to this question. Maybe
Mhm.
you know, maybe you don't know. But we'll use Teams as an example. If someone goes in and after the fact edits a chat, is there information available from the system to let you know what that edit was and
Yes.
when it took place?
Yes. And what the content is.
Okay.
Yep.
So there's
So-
a history of that. So it's a
Exactly.
richer
Yeah.
set of data.
It can
in
be.
some ways,
It can be.
potentially.
You're right.
Okay.
Yeah, it was very interesting. Like this
Yeah.
one, a lot of people I think don't even know you can edit or delete or change,
Yeah.
but I've found the custodians who do, and they do it often. it can be very interesting.
It can be completely innocent
Correct.
and not so innocent.
Right.
Yeah.
Right. So it's something to think about.
Hmm. Okay. What about so one of the things I know that matters to you is the importance of custodial questionnaires.
Mhm.
Has that just always been important, or is it important in different ways now?
I think one, it's always been important,
Yeah.
right? And yes, two, I think it's important for in different ways now. And
Mhm.
one of those, like I said, is when you have a collaboration platform, right? Because it's one thing to say, well, George has email, George has a shared drive. Yeah, George's got a OneDrive. Okay,
Yeah.
so we can go and collect there.
Right.
But
straightforward these days.
correct.
Yes.
But it always wasn't that way.
No, it
And
wasn't.
and I think right now that's what's important about these collaboration platform tools, right? Is it can be difficult for that custodian, as we were saying, to even understand what did they have a private chat? Did they have a group chat? What was the name of those chats? So it's not as easily and sometimes, right? You chatting George may be saved in one location, but also in many different others.
Yes.
And that's where I've found the custodian interviews, custodial questionnaires so important and effective, because you can walk through with the custodian and identify what are the chats, what are the groups that matter.
Yeah.
So
challenges lie ahead. Let's change topics and focus on TAR.
Okay.
And the TAR of today. What works, what doesn't work, what it holds for the future,
what
our challenges are.
I think TAR is exciting in a lot of ways, because my biggest problem, or I think one of the biggest problems in e-discovery, is that there tends to be an arm's length between the team, the merits team, or the team that's trying the case and focusing on the strategy, and what is in the data, where's the data, where does it lie, what does it look like, right? And so we've had these processes in place, I think, where you used to have teams of reviewers, right? They would go through that data, they would tell you then what's responsive or not, or what's hot or not. And what I really like about where TAR is at today is I think we're at a good place, that if you have the right attorneys in place who are on the merits team reviewing those documents, they're able then to see much faster what are the important documents, what doesn't matter. And I think you're just getting better precision and better efficiency, because they have a better handle on what is responsive, what's not responsive in terms of privilege strategy. So I think where we're at today is exciting. Now I think one of the problems is, as we discussed too, right, is does the
system continue to work with
these new sources,
content from the collaboration platforms, the short messages?
Yes.
Or is it now broken?
Yeah, well, right. And I think so sometimes you have to test and carve out. I mean, I've come across literally legal advice that is a emoticon, right? A thumbs up or thumbs down on a contract. Right.
It's
so
still legal advice.
Yes, it is. It's from the attorney. He or she is approving or not the contract. So, but so that brings new challenges to the table. Also, as we talked about, it's a lot less formal, right? So it's not as easy to see, are they referring to an attorney? Are they talking about attorney, or how are things connected? And so, I think the TAR tools out there are catching up, but I'm still trying to see something that can really take all these different snaps and small data that is along with email and others to form that true picture of what's going on with it.
You'd like it to be able to work with very small pieces of data, not just big chunks.
Right. Absolutely.
And you'd like it to be able to work with all of these newer things we're dealing with.
Yeah. Text. I mean, you think about it now, people, messages. I mean, you and I probably communicated via text, email, you'd be chatting.
We could easily have communicated via email, voicemail, text message.
Right.
We didn't, but we could have via Slack or any number of other things.
Right. And which
all one communication.
Which shows, the picture, right, of what we're communicating about. So I think that's going to be the exciting next steps in terms of technology.
What other exciting next steps do you see out there?
Well, I think in the industry, I just think that it's an exciting time. You have like a new generation of people in e-discovery from an attorney standpoint, right? Like the practice kind of formulated 15, 20 years ago, right? And now you're seeing a new generation of attorneys that's all they've done is e-discovery. And then same with non-attorneys and technologists. I mean, I think we are now at a point where the industry is mature. There's a level of respect, right, and acceptance from outside counsels, from law firms, from clients, and I think that just creates so much more opportunity out there for where in the past I think it was a lot less siloed.
What about there seem to be two broad camps for what I'm going to ask. The people who think that e-discovery technology and capabilities largely belongs within the realm of e-discovery. And another camp that looks at these tools and capabilities and says that you can pivot and apply them to information governance, to data privacy, to data breaches, to whatever else.
Sure.
What are your thoughts on that?
I think that I guess I'm in the latter camp. I do think that the technologies can be adapted and used for IG purposes, for privacy purposes, security. I think it's also the reflexive of how a lot of corporations and businesses are designed right now, in the sense that these areas tend to be pretty siloed, right? I mean, I think privacy has been a very hot topic.
Right.
So there's been a large hiring of people in privacy. Security as well, e-discovery, information governance, that can ebb and flow. But I also think, so unfortunately, part of it is the tools are being adopted in those silos as well, if that makes sense. And so I think better coordination, across these different use cases, right? I think there was just a session on data disposition before this talk, and that's an example of you've got legal holds at issue, you've got records, regulatory requirements, business needs, and in terms of retaining that information, how long, how do you analyze that, how do you measure it, how do you know what's there? So I really think that's an area I'd love to see, just the industry as a whole kind of mature together, right, as opposed to these sort of different branches all kind of trying to achieve at the end a lot of the same goals.
What might that maturing together look like?
Well, I think part of it is, I think on the business side, like on the corporation and client side, is having either somebody head of data or from a stakeholder perspective, right, and that's able to see across all of these different units. I think that's part of it, right? You have these competing interests, and I think also it's, as you said too, there's technology, right, and the adoption of the technology that can handle multiple things, right? Like some e-discovery tools handle e-discovery very well. The same thing is with security, right, or privacy.
Right.
But there's a lot of similarities there. There's an analysis of data. There's looking at data. That I think that there's opportunities for convergence.
So on that first part, does this mean we're going to have another CXO in the suite, or do you think one of the existing fill-in-the-blank O's is more likely to become the umbrella for those things?
I think that's a great question. And I think, the challenge there is when you appreciate businesses and how they're structured, I couldn't say that I don't think there's going to be, I think back in the day when e-discovery was just starting, wasn't there like a chief electricity officer back in like the 19 teens, right?
Could have been,
I think
yes.
there was, right? And then they kind of came out of style. I do think, but the point there is, I think you're going to see a type of position really, be that role. Now, the titles may be different just because of the way that an organization is structured, right? But I do think there's going to have to be a data strategy that has legal, right, components and IT, and where that lies in an organization, I think is just really going to depend on the organization itself.
Well, I think we will take that opportunity to let people ponder what the future might bring.
Right.
Draw this to a close.
Sounds great.
Ryan, thank you very much. Ryan Tilot is of Counsel with Gunster just recently.
Yes.
Congratulations again.
Thank you.
I am George Socha. This has been e-Discovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Ryan,
George.
thank you so much.
Thank you.